Good evening to the participants and the students of the SLW 670. You are welcome to the blended class, and we are dealing with the last class what we left over there. Yes, participants, anyone can unmute and read what I posted on the screen so that I could know that you are with me and I am with you and both are sailing in the same boat to reach to the destination. In my last class, I was there, the notice. Notice of the request for the invalidation of the patent shall be served to the licensee under the patent if it appears to the court that the right to the patent belongs to a person who is not a party to the proceeding. Notice of the request of the invalidation of the patent shall be served on that person who shall be entitled to join the proceedings. A person who is a party to the contract to whom that we can sue. But a stranger we cannot sue as per the contract is concerned. In the law of contract, you lent it. That is Dunlop Pneumatic Tire Limited versus Selfridge Company. So there, a person, a company which is not party to the contract cannot be sued. In the same way, a notice should be given to that person who has got the patent to it, but not to the person who did not have such a right to do so. He is not party to the proceeding. Notice of the request of the invalidation of the patent shall be served on the person who shall be entitled to join the proceeding. In case if he is entitled to join the proceedings over there, or he is going to be one of the inventor, at that instant that we can make it out. Otherwise, we cannot make it out because the patent is registered not on his or her name. It is patented on the name of somebody else. If he is really the one of the inventor, then he should be collaborate with and he can jointly made. At that instance, we can serve the notice to the person. That is the same thing which is there, which is not a party to the proceeding. Notice of the request for the invalidation of the patent shall be served on that person who shall be entitled to join the proceeding. If he is entitled to join the proceeding, then such a person will be given a notice. That is actually that want to say it. So when the court issues an order to invalidate the patent or claim, part of claim. So when the court issues an order to invalidate the patent or claim or part of the claim, it shall be regarded as null and void from the date of the grant of the patent, and the decision of the court is not subject to appeal. See, when it is granted, at the time it is a null and void, and an order of the invalidate the patent of claim, and the grant of the patent and the decision of the court is not subject to appeal. When there is no patent itself, where is the question of appeal comes? Appeal comes at that instance only when it is served over there, when the patent is registered and there is a violation would be there. When there is no such a violation, there is no question of appeal. So here they said, when null and void, when there is no patent at all, and from the date of the grant of the patent and the decision of the court is not subject to appeal. From the date of the patent, if it is not null and void, then there is no question of appealing on it. The court shall inform the registrar of its decision of invalidating the patent, and the registrar shall register the removal of the patent from the patent register and publish its cancellation as soon as possible. When the court shall inform the registrar what its decision, what decision, there is no more patent is there, or the patent is invalidated, or there is no norms of patent is made, or the patent is made not following the particular norms. At the time it will be invalidated the patent, and the registrar at the time what will do shall register the removal, and he remove from the register the patent from the patent register and publish it its cancellation as soon as possible. Then he will remove from the register the patent register, and he will also publish it that the cancellation of the patent was done over there. So that is the thing. When patent is invalidated from the beginning, null and void, at that instance there is no appeal for the court decision, and the court will inform to the registrar to remove from the register of the patent and notify to the people that it is cancelled, of the patent is cancelled. So now let us see what is the patent infringement is concerned. The infringement of the patent may be conducted by a person other than the owner of the patent and without the authorization from the owner of the patent in relation to the product or a process falling within the scope of the validity granted patent. It shall constitute an infringement of that patent. Now let us throw light on this point. The infringement of the patent may be conducted by a person other than the owner of the patent. If the other than the owner of the patent is there and without the authorization from the owner of the patent in relation to the product or a process falling within the scope of the validity granted patent, it shall constitute an infringement of that patent. Can a third party who is not invented it can ask for the infringement? The infringement on the patent can be done by a person other than the owner of the patent if he does act such as, in case if he does act in such as. So if he is not the owner of the person patent, and if a third person would be there or the second person would be there, and when he wants to cancel the patent infringement would be there, then he has to follow this condition. What is that? The infringement on the patent can be done by a person other than the owner, means the person who invented it, of the patent if he does act such as. Now let us see the number 1. Uses the patent which has been granted in respect of a product. If he uses the patent which has been granted in respect of the product, that is the first condition. And second, making or importing or offering for sale or selling and using the product. And if that person is making or improving or offering for the sale or selling or using the product. And the third point is stocking such a product for the purpose of the offering for sale or selling or using it. Fourth, uses the patent which has been granted in respect of a process. If the process is granted over there, even though he is not the owner of the patent, but he is undertaking these works. And 5, using the process, if he is using the process. And 6, doing any of the act in respect of the product obtained directly by the means of the process. If he's got the product directly from the means of the process, and in such situations, yes, he can file a case of the patent infringement even though he is not the owner of the property. So again they say, use the patent on the area where the limitation of the right to use the patent is limited, such as, and again they can put the other conditions also. Now let us see what are the other conditions. The rights under the patent shall not extend to acts done for the scientific research. If the rights under the patent shall not extend, it will not extend to the act done for the scientific research. If the scientific research would be there, it will not be effect to it. And the right under the patent shall not extend to acts in respect of the article which have been put on the market in the United Republic of Tanzania by the owner of the patent or with his express consent. So, shall not extend to acts the respect of the articles which have been put on the market, who the owner in the United Republic of Tanzania by the owner of the patent or with his express consent. And fourth, the right under the patent shall not extend to the use of the article on the aircraft, land vehicles, or vessels of other countries which temporarily or accidentally enter the United Republic of Tanzania. Either they temporarily or accidentally enter the United Republic of Tanzania, their right to patent shall not extend to the use of the article for those such persons. Number 5, the right under the patent shall be limited by the provisions on the patent terms. Even the rights also is limited on the provisions of the patent terms and conditions under the Act, what it says. Under the 6, the right under the patent shall be limited by the provisions on the compulsory license for the reasons of the public interest or based on the interdependence of the patents and by the provisions of the government exploitation of the patented invention. So here they want to say the right under the patent Who is having the right under the patent? Is the owner is having the right under the patent. Shall be limited by the provisions on the compulsory license. So, on the compulsory license provisions is there, with that it should be limited the patent for the reason of public interest. The public interest it is protected over there are based on the interdependence of the patents. One to another dependent would be there, interdependent of the patents, and by the provisions on the government exploitation of the patented innovation. So if any other provision of the government for the exploitation in the patented invention, at that instance also it could work. So once the right of the licensor and the licensee have been infringed, they may have the recourse to remedies such as, if once the licensor and the licensee have been infringed, then they may have the recourse to the remedies such as, what remedies are available if the licensee or the licensor may be infringed. Number one, to request for temporary injunction to the court. The request an injunction should be made not to go further. Two, request that the fact of the infringement be declared by the court. They request that what is the infringement fact would be there that be declared by the court. Three, to request an injunction to restrain and forbid the person from further infringing the patent. If any person is infringing the patent, then the person can approach, the owner can approach, the registered body can approach the injunction, restraining and forbidding the person who could not further infringe the patent. Four, to demand a declaration or other appropriate means from the infringer, that is through the publication of the declaration at the infringer's expenses. So they have to publish it that he is the infringer and the injunction is already given and he could not proceed further either for the selling or making any advertisement or stocking such an invention or product. And fifth, to report the matter to the relevant authority in which the infringer will be liable to an offence and shall be liable to pay the fine and exceeding Tanjana shilling 500,000 shillings or imprisonment for a term not less than 5 years or both. Then if the infringer, if he further goes, then they can request the court to interfere in the matter and make the infringer will be liable for an offence, shall be liable to pay the fine, of course, what is provided in the Patent Act and where this patent is registered, and either the money or the both also. And the sixth point is to request the court for forfeiture of the goods if any goods are unsold and kept with the infringer, and let the goods will be forfeited and made through the infringement of the patent. And a person who made such an infringement of the patent, if the goods are unsold over there still, but that will be forfeited by the order of the court. And the seventh point is to demand surrender of the enrichment obtained through the infringement, whatever the enrichment the infringer made, and he should not be enriched himself because the product he did it not of his own and he utilized it by infringing the patent right. At the time, whatever the profits which he got, he should be returned back, and the eighth one damages should be avoided because he is completely infringed the right under the Patent Act for the product which the owner made it or the inventor made it. And ninth, any other remedy provided in the civil law, and they may ask it if any other remedy available in the civil law where the court deems fit to avoid it, it is left to the discretion of the court to do such a thing. So these are all the points will come over there if the patent infringement is there. So point wise we have covered it, how the infringement will make place and how a patent can be cancelled, what are the grounds for the patent cancellation is concerned, and these are the things we read it in our last class as well as in this class. So what is the title of the article which we have gone through is Patent Cancellation and Infringement in Tanzania Mainland. That is the thing. And where we did the patent cancellations And factors, we said number one factor, the surrender of the patent, and then another invalidation of the patent also that we made it. And then we'll come, and the next point is patent infringement that we have seen. Because in the last class, we have seen the notices. The notice of the request for the invalidation potential which served to the licensee, we discussed it in our last class. And in this class, we continued from the notice till the end of this patent infringement is there. So these are all the things we have to keep in the mind, how the patent infringement could be done and what way how the law will protect it. These things comes. But if we happen to see the Tanzania, there is a patent act is already there. I will show you the patent act here. Yeah. See, chapter, there is a cap 217, the Patents Registration Act, the principal legislation it is. So, the title, part 1, part 2, part 3, part 4, part 5, part 6, part 7, part 8, 9, 10, 11, 12, 13, 14, 15, part 16, and part 17, part 18, then the chapters, yes, total part 18 is there. And you see the sections, section 81 are there, saving and the transitional provisions. Then it is the cap 217, what I said, and it's a detail, the Patent Registration Act, which is given over here. So what they say, the preamble of it, the Act to provide the Patent Registration Act so as to make better provision for the promotion of the inventivity and innovations for the facilitation of the acquisition of the technology on fair terms through the grant and regulation of the patent utility certificate and innovation certificates. So these are in the beginning, the title would be there. And again the short title, and we know it, how the patent will work, and how the patent office will be there, where it's headquartered, what are the powers of it, and who is the appointing officer. And if it is asked how a patent could be patented under the cap 257, if I not be mistaken, yes, it is at 217 cap. If the 217 cap would be there, then how it can be made? So one should have to follow this Patent Act, then you have to write the answer, and which is relevant to it. Then we can say how a inventory can be patented. So if you happen to see the patentability, it's a definition, then we can say the right to patent, naming of the inventor, and what are the inventor activities would be there, how the invention made in the execution of the commissioner or by the employees, then grant of the patent, how the patent can be granted. Though it is clearly mentioned in the section 18 application of the grant patent, every application for the grant of a patent shall be made to the registrar and shall contain. So a registrar would be there for him, to him that you have to address it, what shall contain your request. A request should be there, and a description of a thing which you invented, and one of more claims if are there, if that also we should clearly mention, or one or more drawing where necessary, it should be also be given, and an abstract also be given. Then only where the person applying does not ordinarily reside in the United Republic of or the principal place of his business or outside the United Republic, he shall be represented by an agent. Suppose a person is not staying over there in the area of the Republic of Tanzania, and on his behalf of him, his agent can also make the patent over there. So if you happen to see that these are all the provisions, sections 1, subsection 2, and section 3, 4, 5, 6, 7, 8, 9, deals about how the patent could be registered. If you just throw light on the 9th, the details of the requirement for which the application must be prescribed by the regulations made under this act. So whenever you are touching it, we have to touch it also the local legislation, how the international arena would be there, especially in the intellectual property, and how it can be dealt if it is such a international dispute comes in the infringement of the that is intellectual property. Either it may be the patent, or it may be the any other, like TK also that we have seen, that is traditional knowledge also, how it can be made it out. And if the new herbal products are there, if the medicine products are there, and how it can be done also, we have to see it through this respective ads which is there in Tanzania. So now let us see the subject is concerned. Yes, this is the syllabus. And when you happen to see the syllabus, you could understand what are the things and how much we covered and what we are supposed to cover more. So here the course content is concerned, legal framework you have seen. What are the legal framework would be there in the either the Patent Act or Copyright Act or any other act where the intellectual property will be protected. So influence of the TRIP, we have discussed also the TRIP agreements and the international agreements, how it can play the roles in the international level for this intellectual property is concerned. And there is the Tanzania intellectual property law also that we have discussed, and how the mainland would be there, either the cancellation or the invalidation or the registration of a patent is concerned under the Patent Registration Act, that is the CAP 217. Then we also saw the multiple legal frameworks, the international or regional and national level, and the efficacy, the role of ARIPO that we have seen it, and the general issues of the intellectual property is concerned, intellectual property and entrepreneurship. Yes, in the entrepreneurship of the property also we dealt it in our earlier classes, and we have the YouTube and the handout also that I have given to you. Timothy, are you there? Intellectual property and investment, how the intellectual property and the investment relation should be there also we dealt in a depth manner. Then patent law, and we are here the jurisprudence of the developed by the court. What is the jurisprudence developed by the court in the patent concern that we covered up to that extent. So now let us see the next class in the trademark law, that is the counterfeit goods and production of the consumers, how the trademark will work, and intellectual property and electronic comments, internet domain names, how it can be made in the trade. But we also dealt in the patents. In somewhere we also dealt the internet domain. The infringement also. So let us see that how far that we can make it out. So Timothy, are you there? You are not speaking. What is the matatizo? I don't know. The matatizo is, but the time we started is 9:10. Now the time is 9:31. But still we do have sometimes in our hand. So we better to deal with some other things, or we will stop it today and we'll make it the next day the trademark law, and we'll see it. Because up to this section we saw the production of generic resources and traditional TK also we have seen, and the production of traditional knowledge also we have seen, and we have made the comment on it. And then today in the day before yesterday class and today class that we completed the jurisprudence developed by the courts in how the cancellation of the patents, how the invalidation of the patent, how a patent can be revoked, that we studied. In the next class that we will see that, I believe the next class means, I believe it is the Friday. The Friday class we will see that trademark law. By that extent I would like to make it out. But till today now we are going to conduct the test also. Please, when your time is there you can text me. Then how, because you are only one, and hence one is the physical test and one is the take-home test. In the take-home test, generally if the 4 students are there, then we 4 into 3 means 3. 1:3, the ratio that we will give the questions, and is a take-home examination that you can do it in your home. And the next exam would be the physical examinations, and I will frame the questions, and I will make the lottery that which question that you have to attempt, either in the take-home examination or in the physical examination may be there. And if you have any doubts you can ask me, or if you want to come you can come and meet me, and for the more clarification, or you can send the mail and then I will give the clarification to you. So with this, that I would like to stop my today's lecture. Thank you very much. Asante sana, nashukuru sana, Mungu akubariki na kukulinda. Yes.
Wabariki viongozi